now. Okay, so I have a question in the chat. Can everyone hear me? Just give me a thumbs up if you're on video or something. All right, so yes, other people can hear me, so it just must be your issue. Jacqueline, hang on. And so welcome, Magistrate O'Connor. Would you like to go ahead and begin?
Thank you. Good afternoon. First of all, let's talk about access to justice. The courthouse is open. It's conducting all the essential business that it needs to conduct. We actually had a individual call us the other day and say, hey, I heard a rumor that I could commit an F4 or an F5 criminal offense and that I wouldn't get picked up and that I wouldn't get charged for it. Well, we clearly told them, no, that's not the case. You can still get charged and you'll still get arrested for it. So trying to make sure that that rumor doesn't get out there that anybody can go out and do whatever they want to do in Summit County. The courthouse is open. Courthouse employees are essential employees, so we've been deemed to be essential. To balance protecting the employees and the community, though, the court has been working with technology to support employees working from home. So we have a lot of employees that are working remotely. Anybody that can work remotely is working remotely. There are some essential staff, such as myself, my other magistrates that are essential, and I'll get into that later when we talk about what the courthouse is still doing with live people walking in. But first, I want to talk about some of the orders that Judge Corgle-Jones, our administrative judge, has issued recently. On March 24th, she issued our most recent emergency order. That emergency order continued the orders that had previously been filed by the court. And just to recap that, as far as trials, there are no trials that are going to be heard until at least April 10th. So anything that I tell you in the next couple of minutes goes through April 10th, and then we'll talk about what's going to happen in the future. So no trials at all. The Stanley Ford criminal trial, capital case may recommence. That will be up to Judge Croce. That case is the only one that's exempted from the no criminal trials, no trials, period. No inmates will be transported from Summit County Jail. In order to do conferences with incarcerated individuals, they will be video conferenced in through a connection that we have with the jail. Any criminal matters involving defendants that are out of custody will either be done via video conference or via telephone. We do have a Skype form on the Summit County Common Pleas website that the individual criminal defendants can request that their case be heard by Skype. The reason we did it that way was so that we have that connection information with the defendant, so that they've communicated with the court, the defendant has reached out to the court and requested that that case be done. Certainly defense counsel could be encouraging their clients to do that as well. All civil matters will be conducted via video or telephone. We're not having any live civil hearings except for some emergency ones that I'll talk about again later. All mediations are continued unless the parties would like to do them by telephone or by video conference. So it is up to the parties to decide if they want to do it by telephone or video conference. Certainly we are encouraging that. If it doesn't settle over the telephone, then we can reset it for a time later down the road where we could do it in person. All probationers are reporting via telephone or video conference as well. So all of this goes through April 10th at this point in time. Judge Corgle-Jones, who is administrative judge, sends us email updates at least once a week, if not more, to keep the court staff, the judges, and probation all updated as far as everything that's going on with the court and with changes that are happening. Judge Corgle-Jones sent us an email yesterday. In that email, she indicated that while our current emergency order is in effect through April 10th, based on what we've heard from the governor recently, the closing of schools through May 1st, and other items like that, it is very likely that the court is going to be issuing another order within this week that will extend that date. I don't have a particular date right now, but it is very likely that you'll see something more from the court that will extend it past that April 10th date. So let's just start at the beginning of the criminal process, criminal arraignments. How are we handling criminal arraignments? Well, as most people know, anybody that does criminal defense work on any given Wednesday or Friday morning here at the courthouse, we have between 50 and 75, if not more, criminal arraignments that happen every Wednesday and every Friday. Of those, we have anywhere from 20 to 25 generally that are in jail, that are in Summit County Jail, and then the rest are out. So as I just said, we're not doing any criminal defendants that are out of jail right now. So we have a lot of defendants that are out there waiting to be arraigned that haven't been through the system yet. We're doing criminal arraignments of anybody that is in jail as regularly scheduled. So we have the defendants that are in jail, they're video conferenced into the courtroom, prosecutors live in the courtroom. We have a defense attorney that's in the courtroom as well. So that process goes on as it has been. As far as the defendants that are out, well, that's when our technology comes in. So we have set up the Skype program. Again, the defendant can contact the court, can request a Skype arraignment. We would have that individual Skyped in, just like if they were in jail, but they're video conferenced in, I guess kind of like we're doing here now. So they could do their arraignment via Skype. It would be recorded. They would get rolled a judge. We could get them moving on in the system without them having to come into the courthouse. The other option that we have out there is we've developed a waiver form pursuant to Criminal Rule 10B, which allows that defendant to execute that written waiver, of course, with the advice and information of counsel. To have that waiver form be filed with the Summit County Clerk of Courts, we can then schedule that case for an arraignment, get that defendant arraigned, and keep it moving on through the system. So that's one way that we're trying to at least have a trickle of people coming through the arraignment process. Everybody else, we're scheduling them out. We currently have our next live arraignment date set for April 15th. Clearly, that may change, but we're trying to do it on a first in, first out basis. So anybody that was originally scheduled for when this first started, I don't even remember necessarily, but it was maybe the third week in March. So if your defendant was scheduled then, know that they'll be scheduled first, where somebody who just came through grand jury today, they won't be scheduled until later if they're currently out of jail. So that's arraignments. Then we move on to what happens in a criminal case when the judge has already been assigned. As with arraignments, anybody that's in jail is being seen by video conference. All of the judges either have technology in their own courtroom, are accessing the jail, and the defendants are being seen by video in their own judge's courtroom, or the judge is using the magistrate's courtroom or borrowing another judge's courtroom in order to do that video conference with the jail. The defendants and their attorneys have access to a private phone line at the jail so that they can have private communications that are not recorded at the jail. So they have that opportunity to have that conversation. For any defendants that are out, that have already been assigned to a judge, same process. They could use that Skype form. We can use telephone conferences. The most important thing that I could say to defense attorneys or to any individuals that are out that may have a pending criminal case, stay in touch with your lawyer, make sure they have good contact information for you so that they can tell you what your options are and when your next court date may be. So let's move on to other ways that we're trying to use technology. So as in this video conference, the court is working on Zoom and or other video conferencing options. The court is looking at an encrypted video conference, which would allow us to have conferences that would be secure and HIPAA compliant. This is important for our psychodiagnostic clinic, who needs to be able to access individuals at the jail and have confidential communications with those individuals, and to make sure that those communications are not accessible, could not be hacked, and are secure from any outside influence. The courts can also use those in those communications with individuals that are not incarcerated. We can use them for mediations. Mediation communications are, of course, considered confidential. So it would be important to have confidential communications in those mediation communications. So we're working on finalizing that. We talked about arraignment waivers. We also have bridge lines. So the court has bridge lines that are accessible to it. Each court has its own individual bridge line that is assigned to it. So it can set up a conference call that everybody can call into the bridge line. The court calls into the bridge line. Voila, we now have 5 people on a conference call and can be able to conduct meetings that way. All civil cases are being conducted either via video or via telephone. I would encourage any, on criminal cases or civil cases, contact the court. If you have specific questions regarding your case, make sure you contact that specific court. Let them know what your concerns are and what your questions are. Every court is fully staffed. They may be working from home, but every court has access to their telephones, to their emails. You're not going to call and not get an answer. Of course, somebody may have stepped away from their desk and you have to leave them a message, but they'll get back to you, and everybody is doing what they need to do in order to keep the justice system moving. So let's talk about civil cases real quick. So the Chief Justice on March 27th issued an order which tolls time requirements and allows the use of technology. I think at first this is going to create a lot more questions than answers, but eventually I think we'll all get this down and figure this out. What I will say about it at this point is that my interpretation, and having reviewed this with the administrative judge, all time is tolled until the expiration of the executive order 2020-01D or July 30th, 2020. This includes dates set forth in case management orders, dispositive motion dates, trial dates, discovery cutoffs. This order is very, very broad, and it's written very broad, I think, on purpose to allow the individual courts to interpret it, but also to give the parties, let the parties know you don't need to have that deposition done by April 15th, even though your case management order says so. You don't need to file that appeal unless certain circumstances exist. Now, what are those circumstances? Well, if a judge or a magistrate, on discussion with the parties, determines that there is an immediate need, then that judge or magistrate would have to reissue an order that would say, this is an immediate need, this is a case that requires immediate attention, and therefore then a new order can be put on, a new case management order, a new discovery order, to allow that case to continue. Otherwise, the case is stayed. What happens if you have a case that the court has stayed, or the court has said, okay, this is told based on the Supreme Court order, and you feel that there's an emergency issue, that there's something that's come up that you have to talk to the court about, you need to set a hearing about? Contact the court. Do it in writing, do it via motion, so that the court can know this case needs my attention, this is something that I need to take care of. The court is still, as I said, we're still here, and the court is still accepting filings on all types of cases, but specifically we are still doing civil stalking, CPO walk-ins. The process hasn't changed. The individual files the protection order in the clerk's office. They walk up to the courtroom. We're practicing social distancing. We have the courtroom set up in an appropriate way so that we're never within 6 feet of each other. But just as any other CPO, the petitioner gets to make their petition. Decision is made. These are considered emergency issues, so they will continue in their regular course. Hearings will be set within the statutory time frame as they have been in the past. Temporary restraining orders. I had somebody call the other day and say, I might need to file a TRO. Are you guys open? Yes, we're open. You can file a TRO. If you have an issue that needs the emergency attention of the court, you can still file it. Please do. That's what we're here for. Mediations. We are still doing mediations. As I said, the parties are given the opportunity to convert the mediation to a phone mediation if they would like, or if they don't want to do a phone mediation, then we can convert it to a telephone conference to set a new date for the mediation down the line. That's really, sorry, I talked pretty fast. That's really all the information that I have, but I'd be happy to answer any questions if I can.
Great, thank you, Magistrate. Do we have any questions? Please feel free to use the chat function to pose your questions. while you're typing away, I hope, I want to announce that tomorrow at 10 o'clock, we are doing a session like this with Oriana House. And then just this morning, we were able to schedule a session with Akron Municipal Court for an update on their activities. That will take place on Thursday, April 2nd at 1 o'clock. And that will also be here on Zoom. And that'll be with Administrative Judge Nicole Walker. So we'll look forward to having you join us both tomorrow and Thursday. Excellent information, Magistrate O'Connor, timely and helpful. That's a comment. So any other questions or comments? I tried to stream this to Facebook Live as we've been trying to do with the others, and there's some sort of connection issue. I'm recording it and I'll try to upload that for folks who need to look at it later. Still learning how to do some of this technology myself, but I just think everyone in the world is trying to do this right now. Give you just another minute for a question if you have anything, and if not, we'll just let everyone go. We are grateful for the magistrate for her time. Oh, is the court taking any steps to address case management orders issued after March 9th, but that will be affected by the Supreme Court's new order?
Well, if you reading Chief Justice's order, any case management orders issued after March 9th arguably could remain in place. But certainly, I know for a fact that I have a trial that is an emergency issue that we set the trial for April 14th. I don't think that's going to happen, unfortunately. And if any of you are watching, I'm sorry, because we haven't had that conversation yet. But I think clearly we're going to have to revisit that. We're going to have to accommodate the orders of the governor and of the administrative judge here at the courthouse. If we're ordered to not have trials, if we're ordered to not have in-person hearings, maybe we'll have to do a trial via Zoom. You know, certainly that would be an option, you know, where everybody would be in their own individual place. It really wouldn't be any different than what we're doing here now. We would have a court reporter. We could have the trial via Zoom in a civil case, of course, with everybody's consent. So I think it's going to be on a case-by-case basis for the courts to address after, as we each learn the process and figure out what's going on in the future. It changes day by day. As I'm sure we all know, sometimes hour by hour here. And can I say too, if anybody has a question, has an issue, isn't able to get a hold of a court staff, and they want to call my office, I can tell you that my office is staffed. We're always here. I'm happy to try and direct you in the right place. Even if you're not sure who to contact, you're always welcome to call my office so that we can get you in the right direction.
Another question, can we do pleas via Zoom?
So that is a good question. And I know that there have been criminal pleas that have been taken via the direct video conference from the jail. And based on, and now this is my interpretation, but based on the Supreme Court order, the Supreme Court clearly says that the use of technology is permitted and encouraged. So I would assume that if the defendant acknowledges and says, yes, I agree and I will plea, I don't see why there's a problem with it.
Great. Any other questions? All right, well, I will thank all of you for attending. As I said before, had issues, and we've had a couple people join, but since I said it last, we had connection issues to putting this on Facebook Live, but I am recording it and I will attempt to upload that file to Facebook once we're done here and I figure out how to do it. Thank you all for attending. Magistrate, thank you for your time, your preparation in advance. It was a very good presentation. We're grateful for you and for the court for making you available. So everyone have a great day. I've been closing with all of these was please practice your social distancing. Make sure you wash your hands. We want everyone to stay healthy. And we're grateful for all of you for joining us. So take care and have a great day. Thank you.
Thank you. Bye.
Bye.